Hello, everybody. A very good afternoon to you all. My name is Kriti. So, in today's video, we'll be talking about the long awaited verdict on the rift between Mr. Eknath Shinde and Mr. Uddhav Thackeray, which has finally been settled down by the Honorable Supreme Court on 11th of May 2023. So, the judgment that we are going to discuss today is Subhash Desai versus Principal Secretary, Governor of Maharashtra. And this judgment has been given by the esteemed constitutional bench, which was led by the Honorable Chief Justice of India, Mr. D.Y. Chandrachud, and consisting of four other justices. So now, in this video, we'll try to understand that what were the broad issues that were listed before this constitutional bench, and I'll also try to highlight that what were the broad submissions that the parties have made with regard to the present judgment. Before moving any further, let's quickly review that what were the facts and the background of the case which led to this judgment being referred to a larger judge bench, that is the constitutional bench. So, let's quickly see that what was the background of the Shiv Sena party and how this matter came to be listed before the present constitutional bench. So basically, the Shiv Sena party was founded in the year 1966 in Maharashtra. And by the year 2018, the Election Commission of India had recognized the Shiv Sena party to be a state political party, wherein Mr. Uddhav Thackeray was elected as the party president. Now, fast forwarding to the year 2019, the Shiv Sena party, along with the alliances with BJP, was able to form a government in Maharashtra, and wherein Mr. Uddhav Thackeray was sworn in as the Chief Minister of Maharashtra. Moving on to the year 2022, and specifically in June, the constitution of the Shiv Sena party was such that Mr. Uddhav Thackeray was elected as the Chief Minister of Maharashtra, Mr. Eknath Shinde was elected and appointed as the group leader of the Shiv Sena Legislative Party, and Mr. Sunil Prabhu was appointed as the Chief Whip of the Shiv Sena Legislative Party. But in June, there were certain altercations that developed within the Shiv Sena party, which led to the party being fractured into two major fragments, wherein one faction was led by Mr. Uddhav Thackeray, who was the then Chief Minister of Maharashtra, and the other faction was led by Mr. Eknath Shinde, who was the group leader of the Shiv Sena Legislative Party. So basically, the reasons for the altercations in the Shiv Sena party were that in the month of June, certain meetings were held under the guidance of both these members of the party. And in those meetings, certain resolutions were being passed relating to the appointments in the constitution of the party, wherein both these leaders were claiming that the appointments that are made by the faction led by them is legal and valid, and that the appointment made by the rival faction is invalid and unjustified in law. So, since these resolutions were passed and were not being adhered to, thereby the disqualification petitions came to be filed. So basically, the disqualification petitions are filed under the 10th schedule of the Indian Constitution, which provides the anti-defection laws in India. In paragraph 2, subsection 1b of the 10th schedule, it has been specifically provided that if any member of the party fails to adhere to by the directions given by the political party or by a person authorized by it, then such member shall be disqualified for being the member of the assembly and will no longer hold the office of the assembly. And the decision of the disqualification has to be given exclusively by the Speaker of the Assembly. Now, since the disqualification petitions were pending consideration before the court, thereafter in June, specifically on 28th of June 2022, while these disqualification petitions were pending, opposition leader, that was Mr. Devendra Fadnavis, who was from the BJP side, he wrote a letter to the governor to ask Uddhav Thackeray to face a floor test on 30th of June and to prove his majority in the house. Basically, Devendra Fadnavis doubted that Uddhav Thackeray does not enjoy the support of the majority of the House as the CM of Maharashtra, and thereby he must be asked to face a floor test. And based on this communication, the governor asked Uddhav Thackeray to face a floor test on 30th. But before this floor test could be held, on 29th of June itself, Mr. Uddhav Thackeray resigned from his post as the CM of Maharashtra. So now, from 29th June onwards, the office of the Chief Minister of Maharashtra was vacant, and thereby, due to these circumstances, Devendra Fadnavis again wrote a letter to the governor of the assembly, whereby he told the governor that Mr. Eknath Shinde enjoys the support of the majority of the assembly because 106 MLAs of the BJP and 8 other independent MLAs extend their support towards Uddhav Thackeray to form a government in Maharashtra. And based on these communications, the governor called upon Mr. Eknath Shinde to take oath as the CM of Maharashtra, and specifically from 30th of June onwards, the governor of the assembly administered the oaths to Mr. Eknath Shinde as the CM of Maharashtra and to Mr. Devendra Fadnavis as the Deputy Speaker of Maharashtra. But after these two members assumed the office of the CM and the Deputy CM respectively, the governor asked Mr. Eknath Shinde to prove his majority in the House on 4th of July. Basically, after 30th of June, later in a week, the elections for the post of the Speaker of the House were held, and thereby Mr. Rahul Narvekar, who was from the BJP side, emerged to be victorious, and he was appointed as the official Speaker of the Assembly. And immediately after his appointment as the Speaker, he reaffirmed the role of Mr. Eknath Shinde as the group leader of the Assembly and that of Mr. Bharat Gogawale as the chief whip of the Shiv Sena Legislative Party. Now, on 4th of July, since the Mr. Eknath Shinde was supposed to prove his majority, therein he emerged victorious as he won the support of the majority of the assembly, and from that date itself, that is from 4th of July, Mr. Eknath Shinde was declared as the official Chief Minister of Maharashtra. Now, after his appointment as the Chief Minister, on 17th of July, Mr. Eknath Shinde filed a petition before the Election Commission of India under paragraph 15 of the Election Symbols Order, wherein he asked the Election Commission to grant the party symbol of the Shiv Sena Legislative Party, that is the bow and arrow symbol, to the faction led by him. And consequently, on 17th of October 2022, the Election Commission of India made an order and granted the party symbol to Mr. Eknath Shinde and the faction led by him. So now these were the broad facts of the case, and based on these facts, certain writ petitions came to be filed. So the first petition that was filed by Mr. Eknath Shinde, wherein he had challenged the notices wherein the rival group had disqualified the MLAs which was supporting Mr. Eknath Shinde's faction. Consequently, Mr. Uddhav Thackeray also approached the Honorable Supreme Court of India and filed certain writ petitions wherein he had challenged the decision of the governor in calling Mr. Uddhav Thackeray to face a floor test. Secondly, he had also challenged the appointment of Mr. Eknath Shinde as the Chief Minister of Maharashtra. And thirdly, he had also challenged the appointment of the Speaker of the Assembly, that is Mr. Rahul Narvekar. And thereby, these were the broad petitions that came to be listed before the Constitutional Bench. So basically, based on these petitions, this matter came to be first listed before a 3 judges bench, which was led by the then Chief Justice of India, Honorable Mr. N.V. Ramana. Now, before the 3 judges bench, the petitioners and the respondents also had made a contention that substantial questions of law are involved, and thereby this matter should be referred to a larger bench, that is a constitutional bench. And on 23rd August 2022, this 3 judges bench ordered that this matter be referred to a larger bench, and this is how this matter as of today came to be listed before the present constitutional bench. So these were the broad facts of how this matter came to be listed before the present bench, and before this bench several issues were listed for consideration. From now on, we'll discuss that what were these broad issues, and we'll try to take up each of the issues separately and one by one. Let's see that what was the first issue that was in consideration before the constitutional bench. Issue number one. So, the first issue before the bench was whether the Speaker of the Assembly is restricted from adjudicating on the disqualification petitions under the 10th schedule if a notice for his removal has been issued, as held by the court in the case of Nabam Rabia versus Deputy Speaker, which is a 2016 Honorable Supreme Court judgment. So basically, the issue before the court was that whether this judgment of the Nabam Rabia judgment should be referred to a larger bench, because the petitioners were contending that substantial questions of law are involved, and thereby the Nabam Rabia judgment, which is a 5 judges bench, should be referred to a larger bench, that is a 7 judges bench. So basically, the petitioners in this case had contended that the Nabam Rabia judgment must and ought to be referred to a larger bench, because the petitioner said that this judgment is in contradiction to the law laid down in Kihoto Holohan versus Zakilu, which is a 1992 Supreme Court judgment. So basically, let's see that what was the Nabam Rabia judgment about. Firstly, let's see that what was the Nabam Rabia judgment all about. So basically, in the Nabam Rabia judgment, the constitutional bench had laid down that it is impermissible for the speaker to adjudicate on the disqualification petitions once a notice for his removal has been issued under Article 179 subclause C of the Indian Constitution. However, in the Kihoto Holohan judgment, which is also a constitutional bench judgment, it has been laid down that the courts cannot interfere with the disqualification petitions under the 10th schedule at an interlocutory stage, save in the exceptional circumstances. So the petitioners were saying that since both these are a constitutional bench judgment and they are laying contradictory laws, thereby there is a need for this matter to be referred to a larger judges bench. Secondly, the petitioners were claiming that the interpretation of the Nabam Rabia judgment can be misused by the disqualifying MLAs, as they would have the power to disable the speaker from deciding the disqualification petitions. Thirdly, the petitioners were submitting that the Nabam Rabia judgment is in contradiction to the clear mandate and intent of Article 179 and Article 181 of the Indian Constitution. However, with regard to this issue, the respondents were categorically saying that this matter need not be referred to a larger bench, since the Nabam Rabia judgment is based on moral and ethical considerations, and the respondents also said that the Kihoto Holohan judgment only lays down an exception and it does not lay down a general rule, and thereby the law in Nabam Rabia judgment is valid and justified and it should be followed as a precedent. Now, so the court began by analyzing this issue based on the submissions that were made by the parties. Basically, the court analyzed that what is the intent of Article 179 of the Indian Constitution, which stipulates that a speaker or a deputy speaker may be removed from his office by a resolution passed by majority of all the then members of the assembly. So the court, while analyzing this issue, interpreted the meaning and the indication of the word then that has been used under Article 179, and the court reiterated that what has been laid down in the Nabam Rebia judgment, wherein Justice Keher had based his opinion on moral and ethical considerations. So, Justice Keher in the Nabam Rebia judgment had said that it is only just and logical for the Speaker to first establish his right to vote in the assembly, and thereafter he must be allowed to adjudicate on the disqualification petitions. So, Justice Keher in Nabam Rebia judgment had said that the word then used in Article 179 of the Indian Constitution denotes towards the definiteness of the assembly, and it is only proper and logical that the speaker is not allowed to change the constitution of the assembly once a notice for his removal has been issued. And the intent of Article 179 clearly denotes to the fact that all the members of the assembly must be allowed to decide the right of the speaker to vote in the assembly. Secondly, the court also highlighted the observations of Justice Keher in the Nabam Rebia judgment, wherein he had highlighted that under Article 179, first proviso, it has been provided that a 14 days notice period has to be given to the speaker before his removal. So, Justice Keher had said that if this 14 days time is given to the speaker before his removal from the office, then this time period could be misused by him, as he would have the power to change the constitution of the assembly, which is in contradiction to the clear mandate of Article 179 subclause C. So, Justice Keher, in the judgment of Nabam Rebia, had made a remark that if this interpretation is followed, then it would lay down in creating a constitutional conflict between the role of the Speaker as the tribunal under the 10th schedule and that of the role of the Speaker as the prescribed officer of the Assembly, which is clearly not the mandate of the legislature under Article 179 of the Indian Constitution. So, based on these broad submissions, the court in this case had observed that the Nabam Rebia judgment does not apply to the factual matrix of the present case. And secondly, the court also observed that when this matter was listed before the three judges bench, they had made a remark that the Nabam Rebia judgment provides a contradictory reasoning. And based on these submissions and observations, the court, with regard to the first issue, had made a categorical observation wherein they said that since substantial questions of law are involved, thereby the Nabam Rebia judgment should be referred to a larger judges bench, which constitutes of 7 judges. So, with regard to the first issue, the court had said that the Nabam Rebia judgment should be referred to a larger judges bench constituting of 7 judges. Now, let's discuss that what was the next issue that was listed before this bench. Let's see that what was issue number 2 before the constitutional bench. The next issue pertains to the power and the jurisdiction of the High Court and the Speaker and that of the Honorable Supreme Court in deciding the disqualification petitions. So the issue was that what is the power of the High Court or the Supreme Court in deciding the disqualification petitions under the 10th schedule of the Indian Constitution. So basically, this issue arose before this constitutional bench because the petitioners in this case were contending that the Speaker of the Assembly is appointed by the disqualifying MLAs and thereby he is biased and partial, and therefore the courts must invoke their jurisdiction under Article 32 or Article 226 of the Indian Constitution, and thereby they should decide the disqualification petitions. But the court, while analyzing this issue, observed that what is the power of the speaker in deciding the disqualification petitions, and basically the court highlighted that under paragraph 6 of the 10th schedule, it has been expressly provided that the speaker has the exclusive jurisdiction to decide the disqualification petitions. Further, the court observed that under paragraph 6, it has also been provided that the speaker has the power to notify the rules and the procedure that he shall follow in deciding these disqualification petitions, and thereby the speaker of the Maharashtra Legislative Assembly had notified the 1986 rules. So the court observed that as per the provisions of law, wherein under paragraph 6 of the 10th schedule read with the 1986 rules, it has categorically and expressly been provided that the speaker has the exclusive jurisdiction to decide the disqualification petitions. But the court also observed that in the judgment of Kihoto Holohan, it has been laid down that the speaker is a tribunal under the 10th schedule of the Indian Constitution, and thereby, as per the scope of Article 136, 226, or 227 of the Indian Constitution, the decisions that are given by the speaker under the 10th schedule can be subject to judicial review. However, the court noted that the courts must not interfere with the decisions of the speaker in the first instance, and the intent of the constitution is that the speaker must be the constitutional authority in deciding the disqualification petitions under the 10th schedule. So, the court, with regard to this issue, had observed that the courts cannot interfere with the decision of the speaker in deciding the disqualification petitions in the first instance, and they must refrain from such interference. And the courts can only give an opinion or an observation on the disqualification petitions after the decision of the speaker has been rendered. Besides this, the court also discussed that what is the status of the speaker in the parliamentary proceedings, and thereby the court observed that the speaker represents the intention of the house and he represents the proceedings that are held on the floor of the assembly. And thereby the court said that position of the speaker is that he holds a high respect in the parliamentary proceedings, and thereby it is inappropriate for the petitioners to show distrust in him. However, the court also said that it is expected from the speaker to be impartial and unbiased in deciding the disqualification petitions. So the court noted with regard to the second issue that there are no extraordinary circumstances in the present case to invoke the jurisdictions of the High Court or the Honorable Supreme Court of India. And the court also said that the decision should be given with and the court also said that the decision of the Speaker of the Maharashtra Legislative Assembly should be final, and that the Speaker of the Maharashtra Legislative Assembly is the only competent authority in deciding the disqualification petitions under the 10th schedule. So, this is how the second issue came to be decided by this constitutional bench. Now, let's move on towards the third issue. So, let's see that what was the next issue before the bench. So, the next issue before this bench relates to the validity of the proceedings on the floor of the assembly pending the disqualification petitions. So, issue number 3 before the bench was that what is the status of the proceedings that are held on the floor of the assembly between the time period of the misconduct by the disqualified MLA and that of the decision by the speaker. This issue was listed before the bench because of the submissions that the petitioners had made that the MLAs against whom the disqualification petitions are lying should be allowed to participate in the in the proceedings that are held on the floor of the house, but the decision of these proceedings shall be subject to the decision of the speaker in deciding the disqualification petitions. So the petitioners were claiming that the result and the consequence of the proceedings that are held on the floor of the assembly should be made subject to the decision that are given by the speaker in deciding the disqualification petitions under the 10th schedule. But with regard to this issue, the court observed the provisions of law, wherein the court observed that under Article 191 subclause 2, it has been stipulated that any member who has been disqualified under the 10th schedule shall no longer be the member of the assembly. So, any member who has been disqualified under the 10th schedule of the Indian Constitution for defection shall no longer hold the office of the member of the assembly and shall be disqualified from such post. Further, the court also observed that under Article 190 subclause 3, it has been provided that any such member who has been so disqualified under the 10th schedule of the Indian Constitution under paragraph 2 subclause 1b of the 10th schedule read with Article 191 subclause 2 shall be disqualified for being the member of the house and their seat shall thereupon lay vacant. So the court observed the meaning and the interpretation of the word thereupon that has been used under Article 190 subclause 3, and the court said that this term denotes that any member against whom disqualification petitions are lying shall not be disqualified until the decision has been given by the speaker, and they shall have the right to participate in the proceedings. So the court said that any member against whom disqualification petitions are lying shall hold the office of the as being the member of the assembly, and they hold such post until they have been expressly disqualified by the speaker under the 10th schedule. Basically, the court observed that the decision of the speaker and the consequences of the disqualification have a prospective effect. So the court categorically rejected the submissions of the petitioners that the decision of the speaker, that the proceedings that are held on the house shall be made subject to the decision of the speaker, since the court observed that in the parliament there are various crucial decisions that are taken and they cannot be made subject to a future uncertain event. So the court said that if the interpretation that the petitioners have given shall be advanced by this court, this would lead to the chaos in the parliamentary house, which is not the intent of the provisions of law, and the court cannot grant and render such an interpretation to this provision. So the court said that the proceedings that are held on the house on the floor of the house pending the disqualification petitions shall be valid, and any decision and any proceedings that are held on the floor of the house pending the disqualification petitions cannot be laid down to be invalid merely because certain disqualification petitions are lying pending consideration. So the court, with regard to this issue, had said that the appointment of the Speaker of the Assembly, that was Mr. Rahul Narvekar, cannot be declared and called to be invalid merely because disqualification petitions were lying pending consideration before the Speaker of the Assembly, and the proceedings shall be valid, and any member against whom disqualification petitions are pending shall have the right to participate in the proceedings until they have been expressly declared to be disqualified by the speaker under the 10th schedule of the Indian Constitution. So, this was what the court had laid down with regard to issue number 3, which pertains to the validity of the proceedings on the floor of the assembly. Now, moving on towards issue number 4. So, the next issue before the constitutional bench was that what is the role of the speaker in deciding the appointment of the chief whip and the leader of the party, and what is the interplay of the same with respect to the 10th schedule. So the petitioners in this case were basically contending that the courts cannot be allowed to decide on the appointment of the chief whip and the leader of this Shiv Sena party, because they contended that Article 212 bars the courts from making such a decision. But the court analyzed that the bar of Article 212 of the Indian Constitution applies only in the cases where irregularity of the procedure is being considered, and the court said that where there is an inherent illegality, in that case the bar of Article 212 cannot be applied, and where there is an inherent illegality or unconstitutionality, in that cases the courts can subject the matter to judicial review. Now, another submissions that the petitioners had made were that the appointment of the chief whip and the leader of of the party should be appointed by the political party only, since under paragraph 2 subclause 1b of the 10th schedule it has been provided that the direction in voting in certain manner should be given by the political party or a person authorized by it, and thereby the petitioner said that the intent of the provisions of law were that the political party must appoint the chief whip and the leader of the Shiv Sena political party. But the respondents in this case were contending that the term political party and the legislative party are similar to each other, and they are both similar concepts and they can be used interchangeably. So the petitioners were saying that there is no specific and express distinction between both these terms, and the courts can use these terms interchangeably since they constitute for intertwined concepts. But the court categorically rejected the submissions that were made by the respondents, since the court observed that, as per the intent of the 10th schedule read with the 1986 rules, it has been laid and provide that the term political party should be used, and the court noted that the legislative assembly only recognizes the concept of a political party, and the term legislative party has not been used in the constitution of the legislative assembly. So the court, with regard to this issue, observed that the political party has the power to appoint the chief whip and leader of the party. Now, with regard to the scope of the speaker in deciding the chief whip and the leader of the political party, the court said that it is the duty of the speaker in the cases wherein there are two or more factions, and wherein there is a dispute regarding that which group represents real and the recognized political party. Therein the court said that it is the duty of the speaker to analyze the facts and interpret the intention of the political party, and thereby the speaker must decide the disqualification petitions. So while analyzing the facts of the present case, the court observed that since on 21st June 2022 the deputy speaker had accepted the communication of Mr. Ajay Chaudhary as the leader of the Shiv Sena Legislative Party, and the court said that by this time there were no reasons before the deputy speaker to doubt the intention and will of the political party, and thereby the court said that the appointment of Mr. Ajay Chaudhary as the chief whip was valid, But the court said that since the speaker had appointed Mr. Bharat Gogawale as the chief whip in replacement of Mr. Ajay Chaudhary, but this was done after his appointment as the speaker on 3rd of July, and by that time there were enough facts and circumstances before the speaker wherein he knew that a faction has developed within the Shiv Sena party, which has resulted in the Shiv Sena party being fractured into two factions. And since by this time the speaker did not recognize the intention and the will of the political party, thereby the court said that the appointment of Mr. Bharat Gogawale as the chief whip was invalid. Thirdly, the court observed that after on 3rd July, after his appointment as the Speaker of the Assembly, the Speaker immediately appointed Mr. Eknath Shinde as the group leader. And again, by this time, there were certain altercations in the party that had already developed, and the speaker was aware that this appointment has been done by a faction of the political party, and thereby, because of this reason, since the speaker failed to analyze the recognized political party and to analyze the intention and will of the political party, so the court held that the appointment of Mr. Eknath Shinde as the group leader was also invalid. And the decision of the governor in appointing him as the group leader was invalid, and that of the appointment of Mr. Ajay Chaudhary as the group leader of the Shiv Sena Legislative Party was valid. So, with regard to this issue, the court had observed that what is the scope and the intent of the 10th schedule of the Indian Constitution, and whether a speaker can effectively decide the appointment of the chief whip and the leader of the Shiv Sena political party. And as per the facts of the present case, the court gave its observation with regard to issue number 4, that pertains to the appointment of the chief whip and leader of the Shiv Sena political party. Now, let's move towards the fifth issue, which pertains to the impact of deletion of paragraph 3 of 10th schedule. So basically, the issue before the court was that what is the impact of deletion of paragraph 3 of the 10th schedule. Let's see what paragraph 3 was all about. Basically, as we have already studied, that in paragraph 6 it has been provided that the speaker has the exclusive jurisdiction to decide the disqualification petitions, and while deciding these petitions, the speaker has to consider the defenses that are available to such disqualifying MLAs under the 10th schedule. So basically, prior to the year 2003, there were 6 defenses that were available, but as of today, currently there are only 5 defenses that the disqualifying MLAs can use. So now, before 2003, the 6th defense that was provided was regarding the split in the political party. So basically, prior to the year 2003, the 6th defense was provided, which laid down that if there is a split in the original political party, then the member shall not be disqualified, and this defense was available. But with the 91st Amendment Act of 2003, the 6th defense has now been omitted. So the issue was that what is the impact of the deletion of this defense? Basically, the court has simply stated that the effect of the deletion of paragraph 3 is simply that this defense is no longer available to the disqualifying MLAs. And if there is a split in the political party and there are 2 or more factions wherein each faction claims to be the prima facie and the recognized political party, but the conditions of paragraph 2 of the 10th schedule are satisfied, which provides the grounds for the disqualification, and the five defenses that are provided in the 10th schedule are not available to such disqualifying MLAs, then even if there is a split in the political party, then also such member shall stand disqualified. So the court, with regard to this issue, noted that the effect is simply that this defense is no longer available, and if there is a split, it is for the duty of the speaker to first decide that which faction and group represents the recognized political party, and thereafter he must adjudicate on the disqualification petitions. This is what the court had laid down simply with regard to issue number 5, that pertains to the deletion and the impact of the deletion of paragraph 3 of the 10th schedule. Moving on, let's discuss issue number 6. So, the next issue before this bench was that what is the scope of Election Commission of India in recognizing a split in the political party. So, the scope of the power of the Election Commission of India in deciding the split in the political party, this issue came to be listed before this bench because of the fact that time and again in the present case, the question has arisen that which faction actually represents the real Shiv Sena political party. So the court analyzed that for answering this question, it is necessary to determine two proceedings before this bench. That is, firstly, the disqualification petitions under the 10th schedule of the Indian Constitution, and secondly, the allotment of the symbol under paragraph 15 of the election symbols order. So, firstly, the court analyzed that what is the purpose of these two proceedings, and the court said that the purpose of the disqualification petitions is simply to penalize defection and to disincentivize the defection in India. And secondly, the court observed that what is the purpose of the proceedings before the Election Commission of India under paragraph 15, wherein the court stated that the purpose is to provide a uniform procedure for the recognition of the political party, and also to provide a uniform procedure for the allotment of the symbol to the candidates for the purpose of election. Basically, the simple consequence of the allotment of the symbol would be that such member would be allowed to participate in the elections, and the party symbol should be allotted to the faction that has been recognized by the political party. So now the court observed that what is the power of the Election Commission of India in deciding the split in the political party, and the court said that where there are facts wherein there is a split and the party has been divided into two or more factions, therein it is the duty and the power of the Election Commission of India to determine that which faction actually represents the recognized and the prima facie political party. So the court observed that for deciding on this dispute, the Election Commission of India must broadly consider the facts and circumstances of each case, and thereby it should employ the test which is the most appropriate with regard to such facts. So the court observed that in the case of Sadiq Ali versus Election Commission of India 1994, given by the Honorable Supreme Court, it was laid down that the test of the majority is the most appropriate test, and it has been most consistently applied by the Election Commission of India under paragraph 15 of the elections symbol order. But with regard to the present facts, the court observed that the test of majority would prove to be futile, as it would lead to complications in the present case. The court said that in the present case, both these provisions have been concurrently invoked, and thus the test of the majority cannot be applied, and it is for the Election Commission of India to decide on the most appropriate test with regard to the present case. But since the issue pertains to the both these proceedings. The petitioners had also made a contention before this court that this court should provide a constitutional sequence with regard to both these proceedings, but the court said that it is impossible for them to give a sequence to both these proceedings, since the court observed that both the speaker and the election commission of India are competent and independent authorities who have different purposes attached to them, and thereby the court said that it would not be valid for them to put a stay on the decisions that are given by one constitutional authority in anticipation of the decision by another constitutional authority. So the court noted that the decision that the Election Commission of India gives has a prospective effect whereby the symbol is allotted to the recognized political party, and also the decision by the speaker has a prospective effect in deciding the recognized political party. So the court said that when the speaker decides on the disqualification petitions, as has already been noted with regard to the earlier issues, that the speaker must first ascertain the real and the recognized political party and thereafter adjudicate on the disqualification petitions. So the court said that at the time of the misconduct, there shall be only one political party, and thereby the speaker must give a decision based on such recognized political party. So, with regard to the constitutional sequence with reference to both these proceedings, the courts said that it is impossible to give a constitutional sequence, and the court held and observed with regard to issue number 6 that the Election Commission of India and the Speaker do have concurrent powers and they can decide the proceedings before them concurrently, and the courts cannot put a stay on the decisions before any of these constitutional authority in anticipation of the decision before another constitutional authority. So the court said that the proceedings before the Election Commission of India and that before the Speaker can be concurrently held. These were the observations of the court with regard to issue number 6. Now, let's move towards issue number 7, which pertains to the decision of the governor in calling Mr. Uddhav Thackeray to face a floor test. So, as we have already observed from the facts of the case that Mr. Uddhav Thackeray had objected and filed a writ petition before the Honorable Supreme Court of India against the decision of the governor in calling him to face a trust vote on 30th of June. Thereby, this issue came to be listed before the constitutional bench, and herein the court had discussed that what is the power of the governor in calling a member to face a trust vote. So the court, while analyzing and observing this issue, had observed that what is the law with regard to the powers of the governor with regard to this subject matter, and the court observed that in S.R. Bomai versus Union of India, which is a 1994 Honorable Supreme Court judgment, it has been laid down that the decision of the governor in asking a member to face a floor test is an objective fact that has to be established and determined on the floor of the House, and it is not a decision that should be taken by the governor independently. Secondly, the court had also observed that in the judgment of Shivraj Chauhan versus Union of India, which is a 2020 Honorable Supreme Court judgment, the court had laid down that the decision of the governor in asking a member to face a floor test must be based on objective materials and reasons. So the court said that the governor cannot simply ask a member to face a floor test or to simply face a floor test because of the intention of displacing the democratically elected government, and the court said that the governor has a limited power and discretion in such matter, and he should give a decision based on the relevant circumstances only. So, in the present case, the court observed that there were no extraordinary circumstances before governor of the assembly in asking Uddhav Thackeray to face a floor test, and thereby the court said that this decision of the governor was invalid and not justified in law, because the governor in the present case did not have any crucial objective reason and material to call him to face a floor test. Further, the submissions of the petitioners were that since the decision of the governor is invalid, so the petitioners had asked the court to restore his government and to restore the status quo ante, but the court rejected this contention of the petitioners and said that this court does not have the jurisdiction to quash the resignation that has been voluntarily given by Mr. Uddhav Thackeray. However, the court said that if Mr. Uddhav Thackeray would have voluntarily faced the floor test and not resigned before facing the floor test, then this court might have a probability in reinstating his government. But since he voluntarily had given the resignation, thus this court does not have the power to reinstate the government of Mr. Uddhav Thackeray. Now let's discuss the last issue before this bench, that is issue number 8. That is, what is the decision of governor in asking Mr. Eknath Shinde to take oath as CM of Maharashtra. So the court, with regard to issue number 8, observed that the petitioners had made a submission that under Article 164, subclause 1b, it has been provided that any member who has been disqualified under the 10th schedule shall not be a member of the house, and he cannot hold the office of the minister of the assembly. But the court said that the bar of Article 164 applies only in the cases wherein the speaker has given an express decision of disqualifying such member, and merely because disqualification petitions are pending consideration before the Supreme Court, thereby the bar of Article 164 1b does not apply, and the appointment of Mr. Eknath Shinde cannot be called to be invalid because of the bar of 164, since disqualification petitions are still pending before the speaker. Secondly, the court also observed that Mr. Devendra Fadnavis had told the governor that he enjoys the support of the majority of the house, and that he enjoys the support of 106 MLAs of the BJP and 8 other independent MLAs. So the court observed that based on these facts, the governor was compelled to ask Mr. Eknath Shinde to take oath as the CM of Maharashtra. So thereby the court, based on these facts and observations, had noted that the appointment of Mr. Eknath Shinde as the CM of Maharashtra was valid and justified in law. So, with this last issue, this is how all the issues came to be settled by the constitutional bench, and this is how the matter and the rift between Mr. Uddhav Thackeray and Mr. Eknath Shinde has now finally been settled by the Honorable Supreme Court by the judgment of Subhash Desai versus Principal Secretary. Now, this judgment would have a huge impact on the vast political scenario apart from its impact on the Shiv Sena political party, and we hope that it gives a positive impact on the political scenario. I hope that I have been able to raise all the issues and discuss the broad submissions that the parties have made, and this is all from my side. Thank you.